Hello everyone, welcome back to Legally Dephine. In this video, we are exploring the structure of Zimbabwean courts. For easier digestibility, this video shall be in 3 parts: criminal courts, civil courts, and specialist courts. Let's get started with part 1, criminal courts. Courts are classified into 2 broad categories: criminal courts and civil courts. Civil courts are further divided into 2 groups: ordinary civil courts and specialist courts. In examining each court, 2 questions arise. What is the composition of the court and what is the jurisdiction of the court? To answer both questions, reference must be made to the Constitution of Zimbabwe and the relevant Act of Parliament which regulates the court in question. In Zimbabwe, there is specific legislation which prescribes the composition and jurisdiction of each court. The composition of a court refers to its judicial officers, that is, whether a judge or a magistrate presides, the number of presiding judicial officers required to constitute the court, the qualifications the presiding officers must have, whether there is a provision for assessors, and if so, the manner in which they are selected. The jurisdiction of the court refers to its powers and the matters over which it has competence, and also determines its position in the structure of the courts, in particular how it relates to other courts. As I have mentioned, we are starting with the criminal courts. Take note that we also managed to get some footage on the actual courts in Harare. They shall be part of this video. Our starting point is Section 193 of the Constitution, Jurisdiction of Criminal Courts. Section 193 of the Constitution reads, "Only the following courts may exercise or be given jurisdiction in criminal cases: the Constitutional Court, the Supreme Court, the High Court, and Magistrates Court." A court or tribunal that deals with cases under a disciplinary law, to the extent that the jurisdiction is necessary for the enforcement of discipline in the disciplined force concerned. The Magistrates Court is the lowest criminal court in Zimbabwe, and its operations are governed by the Magistrates Court Act and the Criminal Procedure and Evidence Act. Behind me is the Harare Magistrate Court Criminal Division. We have plenty of magistrate courts in Zimbabwe in all the 10 provinces, but this is the one in Harare and it's located along Rotendro Street. A magistrate court is presided over by a magistrate. In criminal matters, magistrates can be divided into 4 classes: ordinary, senior, provincial, and regional. A magistrate's court can be presided over by any of these 4. All magistrates are appointed by the Judicial Service Commission in terms of Section 7, subsection 1 of the Magistrates Court Act as amended by the Judicial Service Act. In terms of Section 52 of the Magistrate Court Act, a magistrate can be assisted by assessors. The circumstances under which an assessor or assessors may be appointed depends on whether the court is being presided over by the regional magistrate or a lesser magistrate. For a regional magistrate, the decision to have an assessor or assessors lies with him or her, but is subject to the directions of the chief magistrate. It is the regional magistrate who decides whether or not to have 1 or 2 assessors. However, he or she must choose assessors from persons qualified in terms of Section 6 of the High Court Act to act as assessors in the High Court. For any other magistrates, the decision whether or not to sit with an assessor requires the Minister of Justice. The minister must also approve the choice of assessors, who in this case need not be persons qualified to act as assessors in the High Court, but be persons with experience in the administration of justice, or persons who have skill in any matter which may have to be considered at the trial. The roles of assessors are limited to matters of fact. This is in terms of Section 52 subsection 3 of the Magistrates Court Act. Section 52 subsection 3 of the Magistrates Court Act reads, Before the trial, the magistrate shall administer an oath to the person or persons whom he has so called to his assistance, that he or they will give a true verdict according to the evidence upon the issues to be tried. And thereupon he or they shall be a member or members of the court, subject to the following provisions. Any matter of law arising for decision at the trial and any question arising thereat as to whether a matter for decision is a matter of fact or a matter of law, and any question arising thereat as to the admissibility of evidence shall be decided by the magistrate, and no assessor shall have a voice in any such decision. The magistrate may adjourn the argument upon any such matter or question as is mentioned in paragraph A, and may sit alone for the hearing of such argument and the decision of such matter or question. When the magistrate has given a decision in terms of paragraph A, he shall give his reasons for that decision. Upon all matters of fact, the decision or finding of the majority of the members of the court shall be the decision or finding of the court, provided that when only one assessor sits with the magistrate, the decision or finding of the magistrate shall be the decision or finding of the court if there is a difference of opinion. The magistrate shall have the sole responsibility for fixing the sentence, but he may consult the assessor or assessors if he thinks fit. Let's start by defining the word jurisdiction. Jurisdiction means the power of a court to try criminal cases, that is to say, the court's power to inquire into and determine whether or not a person is guilty of a crime, and to impose punishment on him if he is found to be guilty. The jurisdiction of magistrates' court is determined by three things: the territory where the crime takes place, the nature of the crime, and the punishment which may be imposed. Regarding territory, the magistrates' court has no jurisdiction over common law crimes committed outside Zimbabwe. In technical terms, it is said that the court has no extraterritorial jurisdiction over common law crimes. However, magistrates' courts have extraterritorial jurisdiction over statutory crimes where the statute in question has extraterritorial effect. For crimes committed in Zimbabwe, the general rule is that a magistrate court has jurisdiction only over crimes occurring in the region or province in which it is established. Regional magistrates courts are established for specific regional divisions. Statutory Instrument 311 of 2020 reads, "There shall be 4 regional divisions which shall be known as the Central Division, the Eastern Division, the Northern Division, and the Western Division. The Central Division shall consist of Masvingo Province and Midlands Province. The Eastern Division shall consist of Manicaland Province and portions of Mashonaland East Province. The Northern Division shall consist of Harare Province, Mashonaland Central Province, Mashonaland West Province, and portions of Mashonaland East Province. The Western Division shall consist of Bulawayo Province, Matabeleland North Province, and Matabeleland South Province." Provincial magistrates are established for specific provinces, and magisterial provinces follow administrative boundaries. Regarding the territorial jurisdiction of Magistrates' Court, Section 56, subsection 1 of the Magistrates' Court Act provides, subject to subsection 1 of Section 49, any person charged with an offence committed within any province or regional division may be tried by the court of that province or that regional division as the case may be. However, in certain circumstances, magistrates' court may try cases that occur outside of their territory. These circumstances are in terms of Section 56 of the Magistrates' Court Act. If a person does something outside Zimbabwe which is a crime under a statute which has extraterritorial effect, any magistrate court can try that crime even if no element of the crime took place within the court's division or province. If any element of a crime is committed within a division or province, the court of that division or province can try that crime even if the rest of the crime was committed elsewhere. If a crime is committed within 5 kilometers from the boundary of a division or a province, or on a vehicle or train which is passing through a division or province, or within 5 kilometers of a division or province, the court of that division or province may try that crime. A person charged with theft or receiving property knowing it to be stolen can be tried by any court within whose region or province he has had possession of that property. A person charged with incitement or with being an accessory may be tried by any court which can try the person who committed the crime concerned. If it is uncertain in which of the several jurisdictions a crime has been committed, the offender may be tried in any of them. With the accused person's consent, the prosecutor general may direct that a trial should be held in any division or province. Magistrates' courts do not have power to try all cases. In terms of Section 49 of the Magistrates' Court Act, no magistrate can try the crimes of murder, treason, or any other crime for which the death penalty may be imposed. And only regional magistrates may try the crime of rape unless the prosecutor general has remitted the case for trial or sentenced to a magistrate who is not a regional magistrate, or the accused is a juvenile under the age of 18, and the prosecutor general has authorized the trial to be held before a magistrate who is not a regional magistrate. The magistrate's jurisdiction as to punishment varies according to the grade of the magistrate concerned. In most cases, the maximum sentence a regional magistrate can impose is a fine of level 12 or imprisonment for 10 years or both. That is the ordinary jurisdiction of regional magistrates, but in certain circumstances, they may impose higher sentences. These are provided for under Section 51, subsection 2, 3, 4, and 4D of the Magistrates' Court Act. In cases of public violence, malicious damage to property, or aggravated robbery, their jurisdiction is increased to a maximum of a fine of level 13 or 12 years imprisonment or both in terms of Section 51, subsection 2 of the Magistrates' Court Act. In cases of theft, stock theft, and unlawful entry into premises, they can impose the maximum sentence prescribed for those crimes in the Criminal Law Codification and Reform Act. For a sexual crime, for example, rape, indecent assault, and so on, they can impose a fine of up to level 14 or up to 20 years imprisonment or both. For crimes relating to dangerous drugs specified in Chapter 7 of the Criminal Law Code, they can impose a fine up to level 13 or up to 15 years imprisonment. In most cases, the maximum sentence a provincial magistrate can impose on a convicted person is a fine of level 10 or imprisonment for 5 years or both. That is the ordinary jurisdiction of a provincial magistrate, but in certain circumstances they can impose higher sentences. In most cases, the maximum sentence a senior magistrate can impose on a convicted person is a fine of level 9 or imprisonment up to 4 years or both. This is in terms of Section 50, subsection 2 of the Magistrates' Court Act, but in certain circumstances, they can impose higher sentences. In terms of Section 50, subsection 1 of the Magistrates' Court Act, the jurisdiction of a court of a magistrate, other than a senior, provincial, or regional magistrate, in respect of punishment for any offence shall be, on summary trial, imprisonment for a period not exceeding 2 years, a fine not exceeding level 7, on remittal by the prosecutor general under the increased jurisdiction given by this paragraph, imprisonment for a period not exceeding 4 years, a fine not exceeding level 9. However, in certain circumstances, ordinary magistrates may also impose higher sentences. The circumstances under which provincial, senior, and ordinary magistrates can impose higher sentences are all the same. These are provided for under Section 51, subsection 1, 3, and 4C of the Magistrates Court Act as follows. In cases of public violence or malicious damage to property, the jurisdiction is increased to a maximum of a fine of level 11 or 7 years imprisonment or both. In cases of stock theft, and unlawful entry into premises, they can impose the maximum sentence prescribed for those crimes in the criminal law codification. For crimes relating to dangerous drugs specified in Chapter 7 of the Criminal Law Code, they can impose a fine up to level 12 or up to 10 years imprisonment. All magistrates are permitted by Section 50, subsection 6 of the Magistrates Court Act to impose corporal punishment up to 6 cuts on convicted juveniles. This, however, is unconstitutional in that judicial corporal punishment of juveniles is a cruel and inhumane punishment. This was decided by the Constitutional Court in State v. Chokuramba. If a magistrate, having convicted an accused person of a crime, considers that the appropriate punishment would be beyond his jurisdiction, he should transfer the case to the High Court for an appropriate sentence. And that takes us to the High Court.